Welcome to We Are Not Lawyers. I'm not a lawyer. I'm John.
I'm not a lawyer either. I'm David.
So welcome for another episode.
And nothing that we say should be construed as...
Legal advice.
Yeah, sometimes it really sounds like it.
It does, doesn't it? Don't misconstrue what we have to say.
No, not at all.
It is not legal advice because we're not lawyers.
No, and you really shouldn't even take it as life advice at all.
No, you can take it for life advice.
Oh, well.
Our life experiences are pretty vast.
Vast.
Vast!
That's right. Every follicle that I've lost was a bit of wisdom.
Absolutely. So, David, you bailed me up outside and said, let's go and do a video. So I'm assuming you've got something you want to say.
Well, yeah, I want to do a general video on the Family Law Act in specifically.
Okay.
And I should say, again, not a lawyer, not legal advice.
No, far from it.
So, yeah, I want to do a video on this because,
Okay.
and just get your hot takes on things.
My hot takes.
I always find those interesting.
Guaranteed to come from left field. All right.
Yes.
Somewhere, anyways.
Yeah, I suppose this is in direct response, I'd say, to a video amongst videos that we've done that dealt with wasn't Jay. We weren't talking about.
No, not Jay. Jay was last week. We're waiting for him.
They haven't hit us up yet.
High conflict.
Yeah, the High Conflict Divorce Centre.
Yeah.
Adam is his.
That's his name, yes.
Yes. If he's the one I'm thinking of, he had a good beard.
What, are you knocking my beard?
No, but his was very thick.
Oh, was it?
If he's the guy. Anyway.
Anyways, yeah, okay.
He might not be that guy. I don't know.
Oh, we jest a lot.
Anyway, he said that he appreciated our work.
So do we.
But then he didn't appreciate that we might have misconstrued what
He was putting forward?
Yeah. And we're not going to retract that video at this stage because I don't believe it to be false. And so one way of perhaps addressing the issue indirectly is by talking about the thing that we're all interested in, including the possible royal commissions that are going to occur, and changing of how they're going to deal with IVOs and how they're going to deal with men's rights issues, even though these have been dealt with over and over and over again.
Yeah, but they don't seem to be coming up with any decent solutions because one band-aid over here causes a problem over there.
True. I do wonder what a royal commission would do though. I think they'd probably. I mean, if it didn't focus on the domestic violence issues, then it will be useless. And I think that they are being granted without evidence. They need to be and at the same time as I say that, we know that actual violence does occur.
Oh, we're not denying that there isn't, family violence out there.
No.
The problem is that the false accusations that keep popping up are taking away resources and money and services from the real violence that's happening out there.
Yeah, and I think that unless I don't think that even a royal commission. I mean, I suppose if one nation, for example, was voted in, then maybe that's sort of a signpost that people are ready to address something or other. But it doesn't seem like it because what we see every day, and I'm guessing Adam, even though he comes from a very different perspective than we do, he'd be seeing every day is that there are unfounded allegations that are determining family matters, and even the ones that don't make it to court because. That famous line that only 3% of these situations.
I apologise for that little glitch. Let's continue.
Can't believe you apologise for something. Fuck. Oh no, you have to bleep that out. Right. So if the Royal Commission can't focus on on evidence
Mm.
and thresholds of evidence, then it's not going to do any good. And I don't think they can do it because of the issue of seen harms. No matter what you do, all someone has to say, like, I mean, imagine that they're having this Royal Commission,
Yeah.
right, and they're having these Senate hearings, and a week in or 2 weeks in, I mean, it's going to happen, right? There's 80 of these deaths,
Happening.
within relationships and the family home. 80, so there's a few a week,
Yeah.
right? And during the hearings, one of these occurs. You think they're going to be able to withstand that? I don't think so, because then you'll get all the green-haired. Fat, I was going to say fat. Feminists.
Feminists.
I mean, green. I'm wearing green, but
Purple-haired.
Purple-haired. Well, green-haired, purple-haired.
Pink, yellow.
Jeans that don't fit.
Yes. Bit of a unusual odour.
I don't know where we're going here, but I don't think they can withstand, because that's how this happens. Is that you have the seen harm, and the legislators, they want to respond. And if that something like that happens, which it's bound to, or even is brought to attention historically, then what are you going to do? Go, oh no, we need to worry about men and their their suicide numbers, which are very related and yet sort of, I don't know, they're not directly related. I wouldn't say. It's more
indirectly.
Yeah, they're indirectly related, and it's more like societal. It's just a product of I don't know, big cities. I don't know, eating too much.
McDonald's.
Well, my daughter now works at McDonald's, so I can't talk out of that. Okay. Moving on. So the way I was going to address this to you, Adam, was that we were going to talk about the Family Law Act, and then you might be able to see why we wouldn't retract
what
the
we've said
about. Yeah, because it's not through malice at all. I'm sure you're a top bloke.
No, I'm sure he is.
Yeah, I mean he does what he's trying to do. So
well, he's actually indicated that he's actually been through the grinder himself.
Yes, and we won't disclose too much of what he said because that's a personal email. So instead, we're going to start focusing on the Family Law Act and the specifics that we are trying to address. And I say we in a non-legal way. We'll say it's more just to highlight to mostly men, but
to educate
and to empower them, because if the submissions that our system generates has the perspective that we're sort of talking about, then it will no longer be just going, oh no, there's an IVO in me, I guess I better take every second weekend. That sort of idea.
Well, look, as we've discovered, most people that we've spoken with in recent times have literally no idea.
No.
They don't know how the system works.
No.
They have no idea what anything means. And it's just total misunderstanding and are totally bamboozled when it actually starts to fall into place.
Yeah.
And they, don't have access to their kids because an accusation's been made. And in most cases, they go running off to a lawyer because we've all been conditioned to believe that lawyers are going to help us.
The panic call.
The panic call, correct.
Yes.
100%.
And after a year down the track, 18 months down the track, some guys 5 years, 7 years.
Are no better off.
Yeah,
no better off.
When they started.
All right.
So let's talk about this. There's a provision in the Family Law Act which is pretty famous, it seems, because if you go onto any of those chat groups, and anyone watching this, you've probably been on all of those family law chat group, men's rights chat groups, any of them really. Yeah. They're going to talk about best interests of the child. So just without me going over any of this, because I always love your hot takes.
My hot takes. Yeah, go on. Best interests of the child.
Yeah, so do you think the court should be able to use the concept of best interests of the child to determine the matter? What do you think? What's your thinking on that? No.
Not unless the child is, well, the best interest of the child. We need to make an assessment of what it is that we're talking about with regards to the child and what age the child is, Are they an infant?
Oh, we're talking, okay, infant.
Right.
Yes,
Are they an infant?
Right.
Are they a teenager?
Okay.
Are they an adult? and the court then, needs to go, well, hang on, is that a parental decision or is that a decision that the court needs to step in for?
Okay, so yeah, that's a good point. You almost sort of refute yourself a little bit. I want to know. So let's go in the band of where they do have, according to you, jurisdiction. So we'll say, from the age of 4 to 13.
Okay.
Just so we're not near the Gillick test, so that you don't have to worry about that one.
The Gillick test. Okay.
Gillick test.
All right. So.
Best interest, should that determine where the child stays, and parental responsibility?
I reckon it's parental responsibility unless it's a life-threatening issue and the parents can't compromise.
Okay. So if they split up, and the parents are saying, the court is saying, we're going to determine who gets custody. We're going to take into account the best interest of the child in order to determine that. For a child that's between the ages of 4 and 13, I know there's a bit to take in.
Yeah.
Do you have any hot? If there's no hot take, that's fine. We'll move on.
No, I don't have a hot take.
All
no
right.
hot take. We're just gonna.
All right, we're going to continue. So this is what it sets out, right? That what the court wants to know is whether the arrangements promote the safety of the child and who has care of the child, including safety from family violence, abuse, neglect, and other harm. What do you think about that specifically? That the court is going to, on its face, yes, I don't mind that. They're saying it's going to look into safety from family violence, abuse, neglect, and other harm. So that's, Adam, if you're listening, and then any others, this is where we might disagree, right? Abuse, neglect, and other harm. Let's just say abuse and neglect for now.
Okay. Yep.
What are those two things? Are they criminal conduct or not?
I believe they are.
Well, it's not just a belief. It is under the Crimes Act of Victoria,
Crimes Act,
and the same for every state. And this would be, under the Constitution. This is how it is. That if you abuse your child, say physically, or it can be demonstrated mentally, especially for a younger child. Neglect, that is if you're not providing shelter to them, if you're not providing food, if you're not providing water, if you're not providing safety, these things are criminal conduct.
Would we be seeking evidence for these or just claims?
No. So what I'm saying is here, I have no issue if the court independently wants to know when it's trying to go, who's going to have custody of the children, whether it investigates whether there's been any substantiated, there's the key word,
Substantiated, yep.
Abuse and neglect. Substantiated, that means in the criminal court.
Yeah.
Like a Chapter 3 court, where it's in criminal jurisdiction, that the accused has had their day in court, and they lost. Right? They've been convicted.
Yep.
And if they've been convicted, it is my belief, yes, the court should do an independent assessment. It finds this out.
Yep.
Via one of our favourite provisions, which is 67 ZBE. I sound like a lawyer.
You do?
I'm not a lawyer, and this is not legal advice. 67 ZBE, which gives the court the power to go and look at these...
assessments.
Yeah, the rulings.
The rulings, outcomes.
And if there are, then yes, no problem. But, and this is where I might disagree with many, if there is no conviction... I say all it is an unsubstantiated allegation, and that it really runs, both ways, right? Because you could have these things without a conviction. Like there's no doubt that these things occur without evidence.
Without
for
evidence.
It. Because someone was too lazy, or someone was caught up in it, or someone was the target of it. Yeah. So and this is the price that we pay. This is and. It's unfortunate that there's always winners and losers. And what I'm saying here is that what the court is doing, if they go and do this investigation, and what they want to drag up is not just convictions, They also want to drag up IVOs,
Yeah.
where the IVO is being used as if it is a finding itself, as if it's a conviction, even though the specific architecture of violence orders is in place so that they don't have to make a finding in order to protect.
Yeah.
That's specifically what it's for. So it's a bit weird, you'd think then.
It is.
For the family court to go, no, we're going to treat it as the very thing it's designed not to be.
100%.
So I say no. If you're doing that, then essentially what you're doing is you're lowering the threshold of what constitutes a crime.
Yeah.
You're saying, well, there was no finding of abuse or neglect in the criminal court, but it's enough for us to go and make a judicial determination that we're going to put the kids over here and over here.
Yep. Yep.
And this is where I disagree, and where our platform is making a stand. This is what we're doing. We're saying, no, we're not going to accept that an allegation is a finding. It never was a finding. It's not a finding now.
It doesn't stand.
No. And so my question to any any lawyers, but I already know what their answer is, and any non-lawyers,
Non-lawyers, yeah.
is what's your position on that? Should the family court be making independent determinations to a lower standard of proof?
Well, we can put it out there to our audience. If you've got a comment to make on it, at the bottom down here, just put in your comments and let us know how you feel about that. All right. What else have we got further on there?
Okay, so that's just one way where we're wanting to challenge the family court.
Yep.
Via submission, because that is how you tender evidence.
Yep.
Right? You file an affidavit, you put a case outline or outline of arguments. We're not lawyers. Shouldn't be
Far
construed-
from it.
Shouldn't be construed as
No.
legal advice. This is just information which you could go into ChatGPT.
Absolutely. Go and ask chat.
Yes, I don't think you'll get a good answer if you ask, should the court be able to? It'll say yes.
It probably would.
It would. So, let's move on. Family reports and single expert model. This is, and we talked about this the other week, under 62G. You can get court-ordered family reports via a family consultant. These are generally psychologists. And they're generally, once the independent children's lawyer has been, they've been allocated.
Yeah.
And this is where, to me, there's a few things happening. Firstly, you're getting incentivization to have these reports and single expert model from lawyers, because they make money from making submissions
Of course
off these things. So it is in their interest to have all of these things going on. Now, the standard approach, we know the standard approach, and just to go back a minute, we know that of the 2,100 family court matters that make to trial, which is not a lot, we know that, it's only 3% of all of the matters that come in, 83% have one or multiple allegations of domestic violence.
They do.
And when that occurs, according to the standard model and architecture that the court uses, and therefore the lawyers will use, they will say that's a high conflict matter. Right? And that's where these guys got their name. High conflict divorce centre. So high conflict matters, and that's when they refer them off to the Magellan list, for example.
Oh, yes.
One of these, or EVAT lists might be a more normal one, where they say,
There's plenty of them.
Yeah, there's a few of them, and I think maybe the EVAT is the regular path. But even still, when you've got 83% of cases coming in with allegations of family violence, meaning that there's high conflict, right? Parties are not going to agree on things. The temptation for the court, which they take, is they then allocate the ICL, and they order, via their orders, family reports and single expert model.
Yeah.
Right? And how do they do that? Well, when one of the parties requests it. I want to know whether other organisations that are trying to help men are advocating, do not allow your lawyer to advocate for one of these things and this architecture. The architecture is the independent children's lawyer, the family report writer, the child impact report, and psych evaluations. Right? All of these things are the standard architecture. And I'm asking anyone out there, any other pro-men's groups, parental alienation, against male suicide, when you're advocating for men and they might be in family court, do you tell them, make sure your lawyer does not
ask for these.
Does not ask for these. And if you did that, do you reckon the man would end up with a lawyer?
Of course he would. If
the man said to the lawyer, I don't want you
to ask for these.
Yeah, do you think that he'd have a lawyer?
No, probably not.
No. Because how they make if they're not if they can't the thing that this does is it makes sure that a matter goes on and on and on.
Yeah, by the time the ICL puts together his report.
Yep, after all these reports, and
we're talking about 9 months down the track.
We are sometimes years. I mean, talk to. Sorry to reference you so many times, Adam. But talk to Adam about this. Talk to me about this. I know. Like this, it takes years.
Yeah,
it takes years. So, and the reason why we say no, we don't want to go down that pathway is simple, right? Now you were going to say something. I know what.
Well, I was sort of toying in my head with what you were saying from the OP side of things. You know, if the other party requests all this, you can deny it.
You can reject.
Yep.
And,
I don't want it.
And then you get to have and okay. So now we're starting to go down the procedural pathway, and this is what we are advocating for. Like we're not saying to use unlawful, illegal, illicit procedures. No, we're saying make your case. The reason why, in our opinion, that we are seeing so many cases ruled one way, and again we can look at the stats: 45% goes to sole custody to the mum, 10% to the man, and the other 45 is shared, but it's all going to the mother basically. We are seeing that, and that's because this process keeps on being going down because it just stacks one layer on top of the other.
And look, the issue here is that most men who end up in high conflict divorces and separations and child custody battles have never actually been told this.
No.
Most of the men that I've spoken to, all of the men that I've spoken to who've been down this path have basically been advised that they have to do it. They have no choice. Well, we're here to tell you that you do have a choice, and refusal is your first choice.
Yeah, 100%. I think that it really is a learning journey for men going through this, but they're going to have to start somewhere, because they can have every royal commission under the sun, but if they don't address the underlying issue, which they can't, then we are left with how to, and it's not just, I shouldn't say it's just men, because it isn't. There are plenty of women where the man is using these sorts of mechanisms.
Oh, 100%.
So I just want to address something that my brain went blank for a second. The procedural pathway, what I'm talking about.
Yeah.
So if you said to your lawyer, and let's just pretend that your lawyer was actually on your side. Like let's. I mean,
why did we both laugh at that?
I know. Yeah, because they're taking the path of least resistance. But we'll go past that. If you said, let's just pretend that the lawyer is on your side, and the man says to the lawyer, okay, I've got an IVO against me. none of these allegations are that, like, they're vague and they're baseless, and I don't know what she's talking about. We might have had some arguments here or there, and that's all. And you said to the lawyer, look, I noticed that you requested an independent children's lawyer and the usual model. Can we do something different and not have that?
Yeah.
And he might go, or she, if it was a female lawyer, yes, okay, because they're on your side. Yes, I agree. And then the lawyer might say to you, what do we do when they advocate for that? And this is when I say, you go down the procedural path. If you don't use your rights, and it's not to guarantee that you're going to get the result that we want, but this is the only way. Yeah. So what does that mean, right? You said, the other party, the lawyer, says, okay, we're going to advocate for the independent children's lawyer. Why do they do that? Well, apart from financial interest, they know that their client's going to win.
That's right, but that's the path that they always choose anyways.
Right. But
and the other thing I was going to say earlier when we were talking about this is well, you mentioned the IVO without any evidence.
Yep.
It's all stacking.
Yeah.
One thing on top of the other.
Yeah.
And then by the time it gets to the final hearing, he's got IVO and ICL and this and that.
Yeah, no, that's right.
It's like, when you get arrested by the cops. I know you haven't been arrested.
I certainly have.
Oh, you have? Oh, okay. Well, the last time I got arrested, they stacked them all one on top of the other.
What the
assault?
The charges,
Charge stacking.
Oh, yeah.
It's part of their process.
No, I know about charge stacking, yes.
And this is the same principle here. They just stack everything on top of each other.
Essentially, it is, because like what you're alluding to is that if it starts with an allegation, then she goes, okay, well, I should say it's just she, but for the purposes of this example, so then she calls the cops and there's now an IVO. So now you've got an allegation and you've got an IVO. You might get a breach as well, who knows? And then you go to the family court. So at the moment, all you've got is this allegation. You might have some child protection in there too, who knows?
Yep.
And so the IVO and allegation. You go to the family court and they go, now we're going to get the independent children's lawyer. Okay, he sits there waiting. And then you get the family report and then you get the child impact report. Both of these at their basis start with the allegations.
Yes.
Right? And it's so they flip the onus of proof. So instead of, and this is why we say to men, shh.
Loose lips sink ships.
Yeah, but even still, that all they'll, in their reports, and this is the language that's used as legal language, they'll say, the applicant or respondent denied. They denied the allegations. And then didn't say further. And we can't say anything further. However, the mother was lovely.
Yes.
Right? So it's stacking all of these things. And so you have now you've got the charge, and the allegation under it, maybe some child protection, maybe a breach of the IVO, you've got the child impact report, you've got the family report, and then you've got the ICL goes, well, I'm waiting, I'm waiting the allegation and the IVO and the reports. I've got to go with those. Yeah. So I recommend that custody go with the mother.
With the mother, yeah.
And that's how it works.
And by the time you get to all of that, it's been 12 months, 13 months.
Yep.
And, it seems to be working quite good. Right. Child's happy there with the mother.
Yeah. So
let's not rock the boat.
Right. And I'm not for supporting a man through that case. I'm not. We are not. No. Our platform is not. Our service is not. What we are trying to do is halt that and go, no, we don't advocate for that mechanism. So let's go down our lawyer path again, where we've said, okay, the opposing lawyer has raised the ICL. Yeah. We haven't. Okay, good start. And the court looks at it and says, okay, well, you're objecting to it and you want it, and we're going to make a determination. And here we are. When they make a determination, if it's for you, great. No ICL, no other machinery. Yeah. But if they rule against you and go, no, we're going to appoint this because now you can challenge that decision.
You can appeal it.
You can. Yeah, that's right. You do an application for review.
Yep.
You challenge that decision. You put your case forward, and they might reject that, and then you can appeal it. And this is what I'm saying. If we don't start pushing back, you will not get any results apart from what is the status quo.
That's right. And we'll change nothing. You know, we keep talking about change. Well, you know, the reasons why we started doing all these podcasts was to teach people and educate them with regards to what their rights are.
Yeah, and I think, and that sort of leads on to perfectly, because we've talked about best interests.
Yep.
We've talked about family reports and that machinery and the ICL, which is also, I mean, just before I leave that,
Yep.
It is interesting to note that an ICL appointment is, in a way, if framed correctly, it's a substitute for judicial determination. In that they are acting in the child's best interest, not as the party's advocate. So they target the absence of any statutory threshold for when appointment is actually necessary. So again, they appoint. So again, this is challengeable, is what I'm trying to say. Stop supporting men to have lawyers that take them to where? To 2 to 5 years paying $150,000 plus if you can afford it, and maybe you'll end up with 50-50 if you're
lucky.
If you're lucky,
Yeah.
but I'd rather take it away from luck and go no. There are processes, and there's many more mechanisms that we're not talking about.
Yeah, absolutely.
And the final one that we're going to go on here is that what we're talking about is that the machinery of the court takes a long time.
Yeah.
Especially if you don't have a whole lot of money either, if you're not going private. So to get an independent children's lawyer, these can be appointed by the court, although they'll come after you for money later. Or, you know, you're doing cross-examination if you're self-represented. You know, you've got Section 102 NA, which means that you can't cross-examine. All of these things, they take a lot of time.
Yeah.
And if you haven't seen your kids in a week, a month, a year, 2 years, then time is of the essence.
100%.
And the only way to attack this, as far as I'm concerned, is not via some machinery that's going to take 12 to 18 months. It's via the mechanism that they provide for you, which is an interim parenting order.
Yeah.
And there are many ways to address that too, because an interim parenting order is actually an injunction. Well, it's a reverse injunction.
It's a reverse injunction, yeah.
Because the injunction is sort of already issued. If you're not seeing your children, that is an injunction on the normal, course of events.
Yeah.
And that has issued without any evidence. And that's the footing that you can challenge, excuse me, for an interim parenting order. We know that the former equal time consideration was repealed alongside the Section 61DA, which is amazing that they did that. But to me, it's the only reason that repealing 61DA would have any impact at all is because lawyers go along with it.
Oh, they just follow the bouncing ball, and like we keep saying, the path of least resistance. They'll just keep going down that road. So yeah, all right. Well, let's wind this one up.
Yeah.
I'm John. I'm not a lawyer.
I'm David, and I'm not a lawyer either.
But we do have some friendly advice from life.
Friendly advice. Anyway.
Till next time, if you like our content, give us a click. Till next time. See you later.